Hello guys, this is Sanjay Arora from New Delhi, India. I welcome all of you on my YouTube channel Legally Determined. Today we would broach on sections 5, 13, 14, 15 and 16 of the Transfer of Property Act 1882 and sections 113, 114, 115 and 116 of the Indian Succession Act 1925. The fulcrum of today's address pertains to the transfer of property for the benefit of unborn person and the doctrine of perpetuity embodied in the Transfer of Property Act. Section 13, transfer for benefit of unborn person, and Section 14, the rule against perpetuity. The scope of the Transfer of Property Act 1882, also known as TOPA, prelude to sections 13 and 14 of the Transfer of Property Act. The Transfer of Property Act has 137 sections, whereas in England, the whole law on real estate occupies 40 tomes. The Transfer of Property Act deals with transfer of property inter vivos, namely between living persons, and not by operation of law, namely transfer under statutory provisions or with the passing of property after demise. The Transfer of Property Act is inexhaustive. It merely amends and does not consolidate the law concerning the transfer of property inter vivos. The Transfer of Property Act is exhaustive on particular subjects dealt with therein, for instance, mortgage, exchange, lease, and gift. With partition, family arrangement, release, etc., not dealt with under the Transfer Property Act. The courts decide according to the principles of justice, equity, and good conscience. The Transfer of Property Act incorporates equitable principles. For instance, Section 53A of the Transfer of Property Act embodies the doctrine of part performance, which is an equitable principle, meaning thereby that where a contract concerning land is partly performed by one party, the court may enforce specific performance if there is not a written contract of the same. In India, the doctrine of part performance operates as a defense in a suit of eviction and prevents the transfer from enforcing any right concerning property against transferee, provided all the conditions laid down in the Transfer of Property Act 1882 are satisfied. The Transfer of Property Act does not apply to easement. The special acts regulating relations between landlords and tenants in urban areas override the Transfer of Property Act 1882. The Securitization and Regulation of Financial Assets and Enforcement of Security Interest Act 2002, being a special act, ousts the application of Transfer Property Act to secure bank loans from companies. The Section 5 of the Transfer Property Act defines the terms transfer of property. The performance of an act by which a living person conveys property in present or in future, first to one or more other living persons, or second to himself, or third to himself and one or more other living persons. Living persons include juristic persons, namely company, association, or body of individuals. The Transfer of Property Act 1882 does not affect any law concerning the transfer of property to or by companies, associations, or body of individuals. The words "or to himself" B token that an owner of property in one capacity may transfer it to himself to hold as owner in another capacity. For instance, a person may transfer property to a trust and constitute himself to be the first trustee. Now, Section 13 of the Transfer of Property Act pertains to the transfer for benefit of unborn child. Illustration 1. It transfers property of which he is the owner to T in trust for H. Here H is a co-beneficial owner and his intended wife W successively for their lives and after the demise of the survivor for the eldest son of the intended marriage for life unborn baby 1 and after his death for a second son UB2 unborn person 2. The interest so created for the benefit of the elder son UB1 does not take effect because it does not extend to the whole of his remaining interest in the property. See infra pictogram 1. Here A is the transferor, T is the trustee, H a qua beneficial owner, W intended wife of A, UB unborn baby, LE life estate, AE absolute estate. Section 13 of the Transfer Property Act 1882 transfer for benefit of unborn persons. Where on a transfer of property, an interest therein is created for the benefit of a person not in existence at the date of the transfer, subject to a prior interest created by the same transfer, the interest created for the benefit of such person shall not take effect, unless it extends to the whole of the remaining interest of the transferor in the property. It means that the transferor must convey to the unborn person whatsoever interest he had in the property without retaining anything with him. Principle. A transfer under the Transfer Property Act 1882 can be effected inter vivos. There cannot be a direct transfer to a person who is not in existence or unborn who may be born in the future but does not have a current existence. Though a child in womb is literally not a person in existence, yet has been so treated under both Hindu law and English law. Thusly, Section 13 uses the expression transfer for the benefit of and not transfer to an unborn person. Unborn here includes who might have been conceived but are not yet born. Indian law contemplates transfers for the benefit of unborn persons in two ways. First, by the creation of a trust where the property is transferred to the trustee, who, though possess the legal title to the property, hold the property in trust for the benefit of the class of beneficiaries who can be unborn persons. Second, under Section 13 of the Transfer of Property Act 1882, the procedure for transferring property validly for the benefit of unborn persons is as follows. First, the transferor to transfer the property for the benefit of an unborn person should first create a life estate in favor of a living person and thereafter an absolute estate in favor of the unborn person. It is not necessary that life interest should be created in favor of only one living person. The transferor is competent to create successive life interests in favor of several living persons at the same time. Second, the person in whose favor a life estate is created is alive. He would hold the possession of the property and enjoy its usufruct. Third, during his lifetime, if the person who on the day of creation of the life estate was unborn is born, the title of the property would immediately vest in him, but he will get the possession of the property only on the death of the life's holder. Fourth, the subsequent conduct of limited owner is irrelevant. The original deed granting both a life interest in favor of a living person and an absolute interest for an unborn person cannot subsequently be tampered with by a limited beneficiary to the detriment of the unborn person. Such attempt will not be valid and cannot create any right in favor of a third person so as to defeat the rights of a person not in existence at the time of the transfer but to whom the interest ultimate is to belong. Under English law, a limited interest can be created in favor of an unborn child but not subsequent to that. Illustration: A on 1st January 1980 executed a deed by which he creates a life interest in his property in favor of his brother BR, and this property is to vest absolutely in favor of B's first unborn child UB. BR on the date of the transfer was unmarried. He took the possession of the property, got married, and a child was born to him in 1985. The moment the child was born, he took a vested interest in the property. The possession continues with BR till his demise in 2000, upon which the life estate will come to an end and UB would take the possession of the property. If UB dies in 1987 during the lifetime of BR, since UB takes a vested interest in the property, he becomes the owner at the time of the birth. Here, the possession of the property continues with BR till 2000 and on his death, the property will go to the heirs of UB. If UB was never born and BR dies in 2000, the property would revert back to A. If he is alive or if he is dead, it would go to A's heirs as if A dies in 2000 leaving behind his property. See infra pictogram 2. The rule under Hindu law and Muslim law. Prior to the enactment of the Transfer of Property Act 1882, the rule under Hindu and Muslim law was that a gift to a person who was not in existence was void. The position under Muslim law continues to be the same. For Hindus, the rule was modified by the following acts to bring it in conformity with Section 13 of the Transfer of Property Act 1882. The Hindu Disposition of Property Act 1916. Second, the Madras Act 1914. Both these enactments were amended by the Act of 1929. The validity of transfer to be assessed by the language of the deed and not by actual events. For instance, A creates a life estate in favor of his friend FR and a life estate for the benefit of FR's first unborn child UB1 for life, and then absolutely to FR's second unborn child UB2. UB1 dies before FR, and UB2 is alive when the life estate in terms of FR comes to an end. Even then, the transfer for the benefit of UB2 will not take effect, as the validity of transfer to be assessed by the language of the deed and not by actual events. It is the substance of the transfer that will determine if it is permissible under the law and not how the situation may emerge in the future. See infra pictogram 3. Section 113 of the Indian Succession Act 1925. Analogous law. Bequest to person not in existence at testator's death subject to prior bequest. A bequeaths his property to B for life, and after his demise to B's eldest son C for life, and after the demise of C to his eldest son D. At the time of the testator's demise, B has no son. Bequest to B's eldest son is a bequest to a person not in existence at the testator's demise. It is not a bequest of the whole interest that remains to the testator. The bequest to B's eldest son for his life is void. See infra pictogram 1. Section 113 of the Indian Succession Act 1925, where a bequest is made to a person not in existence at the time of the testator's death, subject to a prior bequest contained in the will, the latter's bequest shall be void unless it comprises the whole of the remaining interest of the testator in the thing bequeathed. Section 14 of the Transfer Property Act, the rule against perpetuity. The Section 14 of the Transfer Property Act, the rule against perpetuity. It defines no transfer of property can operate to create an interest which is to take effect after the lifetime of one or more persons living at the date of such transfer and the minority of some other person who shall be in existence at the expiration of that period and to whom, if he attains full age, the interest created is to belong. See infra illustration 1. Meaning of perpetuity. Perpetuity literally means eternity or infinity or a long time period. In relation to the transfer property, it means the creation of an interest in present, but which is to take effect after perpetuity. The term perpetuity is not explained anywhere with reference to the specific number of years. It is understood under Section 14 of the Transfer Property Act 1882 as the lifetime of one or more living persons plus 18 years of an unborn person to the max. Under Section 20 of the Transfer Property Act 1882, it has been provided that unless a contrary intention appears from the terms of a transfer, where on a transfer an interest is created for the benefit of a person not in existence, the moment he is born, he acquires a vested interest in it, although he may not immediately be entitled to enjoy it as the property may be in possession of the life estate holder, but the vesting of property takes place at his birth. Unless a contrary intention shows means that this rule of vesting of property at birth can be changed by the transferor and he can stipulate a time of vesting of property in favor of the beneficiary. He cannot stipulate a time of vesting which goes beyond the period of perpetuity. See infra illustration 1. A transfers property for life to B and then to B's first child C. Absolutely. When he attains the age of 10 years, B is living on the date of the transfer but has no child. The property would vest in C till he attains the age of 10 years. The transfer is valid. In this case, when B's first child would be born, the property vests in him till he attains the age of 18 years. If B's first child dies without attaining the age of 18 years, the property reverts back to the transferor or his heirs as the case may be. In the above case, if the property vests in C when he attains the age of 25 years, the transfer is void as the vesting of the property is postponed beyond the perpetuity. Illustration 1. You can have a look-see at this illustration 1 or pictogram 1 it should have been like this. The rule against perpetuity is applicable to both movable and immovable property. Illustration: a gift of a fund to the living son for life, and after him to his unborn sons absolutely, when they attain the age of 21 years, would be hit by the rule against perpetuity and would be void. Principle: the right of the owner of a property to alienate or transfer the property at his pleasure should not be so exercised that it is detriment to the property itself. Since the conferment of the life estate till attainment of majority of the ultimate beneficiary, the property would be inalienable, and that is the maximum period with respect to the inalienability of the property that is allowed under law. Girjesh Dutt versus Data Din, All India Reporter 1934, Awadh, page number 35. S gave away property to R for life and after her death, if there were any male descendants, whether born of son or daughter, to them absolutely. If R had only daughters, they were to have no power of transfer. In the absence of any issues, whether male or female, living at the time of her death, the gifted property was to go to D. It was held that the gift in favor of D was dependent upon the failure of the prior interest in favor of the daughters. Therefore, the gift in favor of D also failed. The development of the rule against perpetuity. It was said in 1861 in the Duke of Norfolk's case. There was a grant of a term of 200 years to trustees upon trust for the grantor's second son Henry and the heirs male of his body. But if his eldest son Thomas died without male issue in Henry's lifetime, then in trust for Charles, his third son, Lord Nottingham held that the last limitation was good, but the case didn't fix the maximum period during which vesting might be suspended, but decided that an interest which must vest with lives then in existence was valid. The modern rule was finally stated in its present form by the House of Lords in Cadell versus Palmer, 1833. In 1883, which decided that a term of 21 years without any reference to minorities might be added to existing lives. There are 9 exceptions to the rule against perpetuity. First, rule against perpetuity does not apply to personal agreements. It is well established that the rule of perpetuity concerns the rights of property only and does not affect the making of contracts, which does not create rights of property. An agreement for the sale of immovable property does not create an interest in the property and is therefore not subject to the rule against perpetuity. It is a personal contract. Second, the rule against perpetuity does not apply to a covenant of preemption and is enforceable against the assignees of the original parties to the contract. Ram Baran Prasad versus Ram Mohit Hajra, All India Reporter 1967, Supreme Court 744. In the instant case, the property was partitioned between two brothers, A and B, with a preemption clause in each other's favor. Namely, if any one of them wanted to sell his share, he had to first offer it to the other brother. Only upon his refusal to buy, it could be sold to others. A offered to sell his portion to B, which he refused, and therefore A sold it to C. Likewise, B sold his portion to D. Further, C sold his property to X and D sold it to Y. X filed a suit against Y and D for preempting the purchase, contending that as Y had notice of this clause of preemption, the same can be enforced against them. Y and D argued that preemption clause was hit by the rule against perpetuity and was therefore void. The trial court held that the covenant of preemption was binding on Y and D as they had notice of it and it was entitled to enforce the right of preemption. They further held that the covenant of preemption was not hit by the rule against perpetuity and was enforceable against the assignees of the original parties to the contract. Third, rule against perpetuity and lease. A lease is not a mere contract. It's a transfer of a right to possess and enjoy the property and can be created for a specific number of years or even in perpetuity. However, rule against perpetuity is applicable only in those cases where there is a transfer of property and the vesting of it is postponed by the period of perpetuity. It therefore does not apply in cases of lease. R. Campraj versus Burton, Son and Company, All India Reporter, 1970, Supreme Court, page number 1872. A executes lease in favor of B with a renewal option given to B, a tenant or leasee, after every 10 years in perpetuity. After 10 years, B exercised the option for renewal and upon A's failure to execute the same, sought the court's help in issuing a direction to A to execute a registered lease deed in his favor. A contended that the condition relating to renewal was hit by rule against perpetuity and was not binding on him. It was held that Section 14 is applicable only when there is a transfer of property, and the clause containing renewal after every 10 years can by no means be regarded as creating an interest in property of the nature that would fall within the ambit of Section 14. Another case, Woodall versus Clifton, 1955 to CH, page number 257. The lease contained a covenant that if the leasee, his heirs, or assignees should at any time during the term of 99 years become desirous of purchasing the ownership of the land, the leaser, his heirs or assignees would execute a conveyance of the premises. The plaintiff, as the assignee of the lease, desired to exercise the option to purchase. The defendants, as trustee of a settlement, were the owners of the land subject to the leases. It was held that the provisions giving the option to purchase were concerned with something wholly outside the relations of landlord and tenant, and could not be said to run with the land, and therefore could not be enforced by the plaintiff. Fourth, charge and the rule against perpetuity. A mortgage is for a fixed term, whereas a charge may be in perpetuity. Mortgage can ultimately be redeemed, but a charge in perpetuity cannot be redeemed at all. There can be no question of redeeming a charge, but only of payment of the arrears of the amount charged due. An agreement to pay an allowance to a person and to continue to pay to a descendant from generation to generation, making it a charge over property, creates only a charge. The rule against perpetuity would not apply to a charge of this kind, since it does not amount to a transfer of interest in property within the meaning of the section. Fifth, mortgage and the rule against perpetuity. In England, it is settled that the rule against perpetuity does not apply to mortgages. A mortgage does not offend the rule against perpetuity because the rule against perpetuity can apply only to cases where there is a new interest in immovable property, contemplated to be created after the expiry of lifetime of a person living and the minority of one who may be in existence then. In the case of a mortgage, there is no such future interest contemplated to be created in property because it is of the very essence of a mortgage that the equity of redemption is a present interest in property, in exercise of which alone the property is sought to be redeemed. Sixth, power of appointment. A general power of appointment gives the holder very broad power to give away the decedent's property. For instance, if the donee can give away the property to anyone in the world, that is a general power of appointment. And for instance, if the donee had the power to select only amongst the decedent's children, that is a special power of appointment. The rule is that where future interests are created under a power of appointment, the perpetuity period is reckoned from the time. First, where the donee appoints if the power of appointment is general. Second, where the instrument creating the power of appointment comes into operation if the power of appointment is special. Seventh, the rule against perpetuity does not apply to land purchased or held by corporation. Eighth, the rule against perpetuity does not apply to transfer for the benefit of public for religious, pious, or charitable purpose. Ninth, the rule against perpetuity does not apply to properties settled upon individuals for their memorable public service. Section 114 of the Indian Succession Act, the rule against perpetuity, analogous law. A fund is bequeathed to A for life and after his demise to B for his life. with a direction that after B's demise, the funds shall be divided amongst such of B's children as shall attain the age of 18. But if no child of B shall attain that age, the fund shall go to C. Here, the time for the division of the fund must arrive at the latest at the expiration of 18 years from the demise of B, a person living at the testator's demise. All the bequests are valid. Say infra illustration 1. Section 15 of the Transfer Property Act 1882. The transfer to a class some of whom come under Section 13 and Section 14 if on a transfer of property an interest therein is created for the benefit of a class of persons with regard to some of whom such interest fails by reason of the rules contained in Sections 13 and 14. Such interest fails in regard to those persons only and not in regard to the whole class. The principle under Section 15 is that as far as possible the transfer should be given effect to. Another case, Raj Bajrang Bahadur Singh versus Thakuren Baktraj Kuver, All India Reporter 1953, Supreme Court, page number 7. In the instant case, a person A died in 1930, leaving behind a son S1 and a widow of another son S2W. Shortly before his and his son's demise, A executed a will in favor of S2 and after him a life interest in favor of his widow and unborn heirs by provisions of their maintenance. S1 claimed property on the ground that the will is invalid and he is the rightful heir of A. S1 contended that as the will created a life interest in favor of S2's widow and his unborn heirs, this not being permitted under Section 13 of the Transfer Property Act 1882 and under Section 113 of the Indian Succession Act 1925, the will was void. The court held that it is quite true that no interest could be created in favor of an unborn person, but when the gift is made to a class or series of persons, some of whom are in existence and some are not, it does not fail in its entirety. It is valid with regard to the persons who are in existence at the time of the testator's death and is invalid as to the rest. The widow, who was the next heir of S2, was in existence when the testator died, and the life interest created in her favor would certainly take effect. Her acquired interest in the will was commensurate with the period of her life and till she was alive. S1 had no right to claim possession of the property. Prior to 1929, the rule was that if by the same transfer an interest was created in favor of a class of persons, with regard to some of whom such interest fails, by reason of any of the rules contained in sections 13 and 14 of the Transfer of Property Act 1882, such interest fails as regards the whole class. Illustration 1. A transfers his property to his son B for his life, and then to his grandson GS when he attains the age of 18 years, and to his granddaughter JD when she reaches the age of 21 years. B had no child at the time of the transfer. The transfer created a life interest in favor of his son B, which is permissible in law. The transfer for the benefit of the unborn grandson of A was valid, but for the unborn granddaughter of A is void as violative of the rule against perpetuity. See infra pictogram 1. Analogous law. Section 1 and 15 of the Indian Succession Act 1925. The bequest to a class, some of whom may come under rules in Section 113 and 114 of the Indian Succession Act 1925. If a bequest is made to a class of persons with regard to some of whom It is inoperative by reason of the provisions of Section 113 or Section 114. Such bequests shall be void in regard to those persons only and not in regard to the whole class. Illustration: a fund is bequeathed to A for life and after his demise to all his children who shall attain the age of 25. A survives the testator and has some children living at the testator's death. Each child of A living at the testator's death must attain the age of 25 within the limits allowed for a bequest. But A may have children after the testator's decease, some of whom may not attain the age of 25 until more than 18 years have elapsed after the decease of A. The bequest to A's children, therefore, is inoperative as to any child born after the testator's death and in regard to those who do not attain the age of 25 within 18 years after A's death, but is operative in regard to the other children of A. Section 16 of the Transfer of Property Act: no transfer to take effect on failure of prior interest except alternative transfer, where by reason of any of the rules contained in sections 13 and 14 an interest created for the benefit of a person or of a class of persons fails in regard to such person or the whole of such class, any interest created in the same transaction and intended to take effect after upon the failure of such prior interest also fails, except alternative transfer, which is valid. See infra illustration 2. Illustration 1. A transfers property to B for life and then to B's sons on their attaining the age of 25 years. If B dies without any son, the property would vest absolutely in C. B and C were living on the execution of the transfer, but B had no child on the same day. Here the transfer for the benefit of B's unborn children was void, as it violated the rule against perpetuity. Thus, the transfer in favor of C that was intended to take effect upon failure of this prior transfer, that is void, would also fail and cannot take effect. See infra pictogram 1. Illustration 2. A makes a transfer of property to B and then to B's children on their attaining the age of 21 years. If B has no child, B may make the gift in favor of anyone B likes. The transfer for the benefit of B's unborn child was void, as offending the rule of perpetuity. But the transfer at the behest of B is an alternative and independent transfer that would commence from B and not A, and therefore would be valid. Alternative and independent transfer. Pictogram 2. Analogous law, Section 116 of the Indian Succession Act 1925. No bequest to take effect on failure of prior bequest, where by reason of any of the rules contained in Section 113 and 114, any bequest in favor of a person or of a class of persons is void in respect to such person or the whole of such class. Any bequest contained in the same will and intended to take effect after upon failure of such prior bequest is also void. Illustration 1. A fund is bequeathed to A for life and after his death to such of his sons as shall first attain the age of 25 for his life, and after the decease of such son to B, and B survive the testator. The bequest to B is intended to take effect after the bequest to such of the sons of A as shall first attain the age of 25, which bequest is void under section 114. The bequest to B is void. So, I have dwelled on the concept of the transfer of property to for the benefit of unborn child and the rule against perpetuity. You must have understood the concept, which is a little bit complex. And please like, share, and comment. Thank you. Break a leg.